$300 worth of items, over $300 worth of items for $600 to $800. He says his friend brought the trailer to him. The evidence that was elicited at trial indicated that a window of the truck was broken. So it's pretty clear to me that he knew these items were, the very least, he knew these items were stolen.
Jose Lozano was found guilty of stealing $300,000 worth of items, including military medals and family heirlooms. He claimed he paid $800 for it all, no questions asked, but his story fell apart. Was it a bad deal or a planned theft? Watch.
The case begins with the shocking details. $300,000 worth of stolen property, including military medals and family heirlooms. Jose Lozano claims he paid only $800 for everything, no questions asked. But the evidence tells another story, a broken truck window and boxes of stolen memories. What do you think? Was this just a bad deal or a well-planned theft?
And decide, did the judge get it right?
All right. Ladies and gentlemen, what's going to happen now? Both sides have rested and closed. I'm going to read to you the jury charge, or what's called the charge of the court. You do not have to memorize that. You will be given my copy to take back with you to the jury room. Charge of the court. Members of the jury, the defendant, Jose Lozano, stands charged by indictment with the offense of theft, $300,000 or more, alleged to have been committed on or about the 4th day of December 2020 in Bexar County, Texas. The defendant has pleaded not guilty.
The judge reads the formal charge, theft of property valued at $300,000 or more. Lozano pleads not guilty, but the law is clear. If you take what isn't yours without consent, it's theft. The jury's task is simple, guilty or not guilty. You can already feel the tension in the room. This verdict will change a life.
1. Our law provides that a person commits the offense of theft if he unlawfully appropriates property with intent to deprive the owner of property. Appropriation of property is unlawful if it is without the owner's effective consent. 2. Appropriation and appropriate mean to acquire or otherwise exercise control over property, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room. All right, ladies and gentlemen, the court has been informed that you've reached a verdict. Is that correct? And is that verdict unanimous? All right, if you'll hand the charge to Deputy Laura for me, please. All right. The verdict form reads, we, the jury, find the defendant, Jose Lozano, guilty of the offense of theft, $300,000 or more, as charged in the indictment. You may be.
After days of testimony, the jury returns with their decision. We, the jury, find the defendant, Jose Lozano, guilty of theft of $300,000 or more. Each juror confirms it, unanimous. The courtroom falls silent. Lozano stands, facing his fate. His lawyer requests time before sentencing, and the judge agrees. The stage is set for punishment day.
Your Honor, this is a first-degree felony, so and I believe he's had some trouble on bond reporting, so we are asking to be taken into custody, Your Honor.
All right, with regards to the issue of whether or not there's been some concerns about bond, have there been any bond issues?
I'm unaware of that, Judge, but I'm not sure I've been on the case.
So it's just hired a lawyer that he didn't got
I had a
out.
previous lawyer. I'm not sure why we changed, but somehow I got this.
We can confirm the dates, Your Honor, but when he was arrested for this offense, it was because he had failed to appear, I believe.
And it was an affidavit of surety back in August of 21.
All right.
Well, as you know, Judge, bonds may get off bonds for all kinds of reasons. Business is non-compliant with court orders. It could be that he got sideways with them for whatever reason. But like I said, I wasn't on the case at the time. I know that he's always been here, every day for trial on time. He has a great interest in seeing this case to a conclusion. I'm anticipating an appeal, a request for an appeal bond, so I'm sure he'll want to be on his best behavior in order to get that.
All right, so this is what the court is going to do, because it appears that the defense may need to prepare argument as to why he shouldn't be in custody. So I'm going to give you all a chance to confer and state for you a chance to look to see if there's a reason why he shouldn't remain on bond, and defense give you a chance to look at what they have for the court. All right. So he's going to remain here in the courtroom, and he's not allowed to leave the courtroom. I'm going to go talk to the jurors briefly. If anyone else would wish to talk to the jurors, you're more than welcome to do so. All right, everyone, please have a seat. If you're not on this case, court is calling 2021 CR 7016, State of Texas versus Jose Lozano. Can I have the parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Raymond Martinez for Mr. Lozano.
And are you Mr. Lozano? All right, we are here for sentencing. A jury found you guilty. Just one moment. And they found you guilty of the offense of theft, $300,000 or more as charged in the indictment. Have both parties had a chance to review the PSI report? State.
We have, Your Honor.
Defense.
Yes, Your Honor.
Any corrections or additions to the PSI report? State.
No, Your Honor.
Defense.
No, Your Honor.
All right. State, what are you requesting?
Your Honor, we're asking that you sentence the defendant to 15 years in the prison.
All right. And the reason?
Your Honor, the defendant was convicted of a first-degree felony offense in this case. Reading the TAP evaluation, he's shown no remorse for his actions. He doesn't say this was the result of being under the influence of drugs or alcohol. His story about how he says this happens is just not credible. Doesn't jive with the evidence that we saw at trial. He says that someone offered to sell him $300 worth of items, over $300 worth of items for
Weeks later, the prosecution begins strong. They want 15 years in prison. They point out Lozano's unbelievable story, buying a trailer of valuables for $800, pretending he didn't know it was stolen. The prosecutor's words cut deep. These victims lost what can't be replaced: medals, photos, family history. This isn't just about property. It's about memories stolen forever. Would you call that just theft or something deeper?
$600 to $800. He says his friend brought the trailer to him. The evidence that was elicited at trial indicated that a window of the truck was broken. So it's pretty clear to me that he knew these items were, the very least he knew these items were stolen. But Your Honor, what he's convicted of is theft. And I guess the other part of this, the TAP evaluation, they talked about his home life a little bit. He says he has regular contact with all his kids, but evidence elicited at the trial was he's not paying any kind of child support to Edith Serrano. That was one of the victims, you may recall, Your Honor. Or I'm sorry, one of the witnesses at the trial, Your Honor. I know you were presided over this case, Judge, so you remember the testimony, but Terry Kirkbride and his wife are moving from California to Florida, and they lost almost everything as a result of this theft, Your Honor. But what Terry said on the stand is what really stuck with me. And what he said is the hardest part about this is that he lost things in this theft as a result of this theft, as a result of the actions of the defendant that cannot be replaced. So the hardest part of that for him were the photos that are just gone forever. The things that he inherited, the things that his wife inherited, they're gone forever. Items from his military career that are gone forever, damaged or lost. And so that's what I want to emphasize to the court. And the other part of the thing I want to emphasize to the court, Your Honor, is we're asking for this sentence to protect the community from these types of thefts. This property crime, I think, especially folks who are involved in the criminal justice system, we can get sort of jaded and think, well, nobody died, right? But these crimes are very serious, and the victims in this case lost nearly everything that they own. And so, Your Honor, we're asking that you protect the community from these types of crimes and sentence the defendant to 15 years in the prison.
All right, defense.
Judge, if the court recall from the facts of the case, I think Mr. Lozano's explanation is perfectly plausible. There was absolutely no evidence presented by the state in the trial of the case that he was present when that truck was stolen, or that he ever drove that truck, ever had contact with that truck, it was ever on his property. His suggestion that the guy brought the trailer to him to see if he wanted to buy it is consistent with somebody who did steal that property, trying to go and pawn it off on people. Him paying $600 or $800 for what was the contents is because all the valuables were already gone. All that was left was a bunch of stuff that after whoever stole it poured through it. He admitted, yes, my print is on the trailer because he showed it to me, and he wanted more money than I could afford, and so I didn't buy it. He offered me the other things that were there. The complainant specifically testified in his testimony the things that were at Mr. Lozano's property that they recovered were of little or no value, right? If you look at the PSI report, when they go to the restitution, it says approximately $300,000. How can you approximate that when he's already been found guilty by a jury? Well, this court knows why. It's because her math was a mess. The complainant testified in the trial of the case that he agreed in writing a contractual agreement with the insurance company to settle for $240,000. The theft statute is very, very clear. It's the value of the property at the time it's stolen, not what you paid for it years before. So when you read their exhibits, and the jury obviously never did, they put no attention to the real evidence in the case. They felt bad for the complainants. I feel bad. We all do. They suffered a great loss, but they didn't prove he was the one who did it. They proved that he was a party to being in possession of some of the stolen property. That's why we had a jury charge all the way down to a state jail. That was the appropriate charge. This case is ripe and full of appeal issues, especially on the issue of the value and sufficiency of evidence. This case does not merit a day in prison. I get it. It's a big loss. But if you look at the exhibits, and I was going to bring it to you, but it's in the court's file or court board's file. USA went through an exhaustive list, and he says I spent months and I kept updating it, telling them all the things that I lost. They put the retail value, they depreciated it down to the actual cash value at the time of the loss, right? He signs an agreement, accepts the check saying $240,000.
Now, Lozano's attorney fires back passionately. He argues there's no proof Lozano ever stole the truck or was involved in the burglary. He says Lozano was merely shown the trailer, touched it maybe, but never stole it. Then he challenges the evidence value. They settled for $240,000 with insurance, not $300,000. The math doesn't add up. He insists Lozano deserves probation, not prison, saying locking up every buyer of used goods would fill the jails overnight. Do you agree? Should someone go to prison for buying stolen goods without knowing?
Yes.
All right, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Jose Lozano.
All right, and make sure you keep your voice up so the court reporter can hear. Who's the name of the friend that gave you these items?
What's his name? I don't know his name. They called him.
Well, I mean, you say he's your friend,
Well, yeah, but
and you say you received a phone call from a friend.
yes, should have wrote it down.
All right, so here's my other question. The items, because there were some items that were related to his military career. When you saw the name of a person's name on military paperwork, what did you think?
At the point already, I had the stuff in my house. I didn't know what to do with it no more. It was there. I bought it. It was in boxes when I bought it. By the time I got to open it, I saw the stuff.
So how much money did you pay for this stuff?
About 800, whatever was in the trailer, I got it off. About $800 and $900.
Did you look through everything before you paid $800?
Finally, Lozano himself takes the stand. When asked who sold him the items, his answer, I don't know. I forgot his name. The judge looks unimpressed. Lozano admits he didn't even look inside the boxes before paying. The judge compares it to a storage wars gamble, except this one came with stolen memories. That moment said it all. His story didn't hold up.
Court is going to sentence you to 6 years in the prison, give you credit for any time served. With regards to the amount, the court does not deal in approximations. So for the court, there is no restitution because there is nothing here to suggest a restitution amount. It just says approximately $300,000. There's nothing I can do with that. And this trial was on March 21st. I'm sorry, just one moment. Yes, March 2024. So by that time, there should have been some amount to the court. So I'll give you credit for any time served. Is there anything else with regards to sentencing, State?
Judge, is the defendant's birthday, May 1st, 1998? Is that right?
You can ask him.
Okay. Is that your birthday, sir? May 1st, 1998?
Yeah.
And Judge, would you incorporate the evidence at trial as to the value? Would that be something you'd be willing to do?
No, because again, the amount that's listed in the PSI report is approximately $300,000. And then defense counsel is correct with the amount that the complainant settled for. And I know how insurance companies do sometimes.
Probably
The amount, yeah, the amount the insurance company settled for was $240,000.
Then, the judge delivers her ruling. The court is going to sentence you to 6 years in prison. She refuses to assign restitution, saying the court does not deal in approximations. A clear message, emotion can't replace evidence. Lozano's casual ignorance cost him his freedom. 6 years, too harsh or too light? What would you have decided?
So this is where we are.
If I could, just one last thing on the record. I just wanted the court to be aware, the record to be clear, that approximation comes from the complainant. The PSI officer called the complainant to ask him that number, and that was his response,
Yes.
even after his testimony that was presented to the court.
I'm not ordering restitution unless there is some sort of deductible, which the court has not received any information on a deductible amount. So the court will sentence you to 6 years in the prison and give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor, we just have victim impact fees.
I do, Judge.
Yes.
We will be filing notice of appeal and a request for an appeal bond. Do you want to take that up today or?
Oh, you have to file the motion and the court will take that up. So if you could have him fill out the trial court certification.
Well, they're going to be filed today. That's why I'm asking if he could be kept in court today so we can address it, or.
It's going to have to be another date. All right. If you could have him do the trial court certification, so I could do that now, please.
Do my magic here, it's backwards.
Yes. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
All right, you have a right to an appeal as this was a jury trial.
Lozano got 6 years in prison, no restitution, but the judge made it clear this was more than theft. A family lost their memories. Lozano couldn't even name the man he bought from. Was 6 years fair? Too much? Too little? Comment below and subscribe for more real courtroom drama.
As Lozano signs his appeal paperwork, the judge reminds him, this wasn't just about money. A family lost pieces of their life. The victim's memories, photos, heirlooms, medals gone forever. The court might call it theft, but to them, it was a personal tragedy. Professional summary Jose Lozano was convicted of first-degree felony theft, stealing property worth over $300,000. Despite claiming innocence, the evidence, the missing details, and his own unclear story led to 6 years in state prison with no restitution ordered due to conflicting amounts. This case shows that in court, credibility matters more than excuses. And sometimes, what's lost can't be bought back. Call to action, CTA. What do you think? Was 6 years fair for this crime? Or should the punishment have been stronger? Drop your thoughts in the comments, like this video if you found the case interesting, and subscribe for more real-life courtroom drama and verdict analysis.